This is Newsroom. Hello and welcome from Johannesburg here in South Africa. I'm Eben Jansen. Of course, this show is always live. It's broadcast from our studios in Auckland Park. We're also streaming live on YouTube right now with our whole show available on demand on our YouTube channel. Today is Judgment Day. Judge Thokozile Masipa will start delivering judgment in the sensational Oscar Pistorius murder trial live on this very channel in about 30 minutes' time. Today we'll be live outside the court with Griselda Lewis, and we'll look at a couple of scenarios here in studio that could play out with the judgment. But before we go there, let's take a look at today's news with Katrine Milan.
Well, hello and welcome you with Newsroom. I'm Katrine Milan, and let's take a look at the top stories this morning. The world and the media's focus is at the North Gauteng High Court as Judge Thokozile Masipa begins handing down her verdict in the Oscar Pistorius murder trial today. The judgment, which is expected to take 2 days to deliver, will begin in 30 minutes' time. Pistorius allegedly shot and killed his girlfriend Riva Steenkamp on Valentine's Day last year. He's charged with premeditated murder as well as 3 firearm-related charges. Pistorius has pleaded not guilty to all 4 charges. The verdict will finally bring to an end the grueling trial. 22 police officers and 2 other people in Welkom will appear in the court tomorrow on charges of corruption, theft and money laundering. The Hawks arrested the warrant officers, captains, constables and 2 community members for contravening the Precious Metals Act. Counterfeit money was also found in their possession. National Police Commissioner Ria Pieja told the Farlam Commission that she could not remember the details of the plan to disarm Marikana miners. She was being questioned regarding a meeting senior police officials held in Midrand on the 15th of August 2012, when the police's intervention plan for Marikana was adopted. The Commission is investigating the deaths of 44 people during the strike-related violence at Lonmin's Marikana mine. Police opened fire on a group of striking mine workers, killing 34 on August 16th, 2012.
That detail, as I say, I'm not able to say yes or no to, because I'll be doing some injustice, because you would want me to say who was saying that. I don't know. That discussion must have taken place, because we're discussing this disarming and whatever. I'm not able to give those pedantic details, Chairperson.
In your world headlines this morning, crowds are expected to gather in New York City today for the 13th anniversary of the September 11th World Trade Center terrorist attack. Nearly 3,000 people were killed. Families of those who were killed will gather at the World Trade Center site for a special memorial service. Moments of silence are expected to be held at the Ground Zero site, timed to the moments the 2 jets crashed into the towers and when the buildings fell. And 4 points from a possible 6 in the first 2 African Cup of Nations qualifiers have left Bafana coach Shakes Mashaba believing that his team is on the right track. He was speaking after an entertaining goalless draw against the African champions Nigeria at Cape Town Stadium last night.
It was a game of nerves. Chances were created on both sides. Players started playing well from both teams. It went on in stanzas. We had Nigeria getting an upper hand. We also come back, we had an upper hand. But truly speaking, we should have sealed it in the last 10 minutes.
Now remember, all these top stories are available on our Newsroom Facebook page. You can also follow us on Twitter at SABC Newsroom. Eben, over to you.
Thank you, Katrine. Justice will be dispensed one way or the other today. Oscar Pistorius will either be freed or face a future behind bars. If found guilty, there is little doubt that he will appeal. After 19 months, though, the Paralympic star and the world will finally know his fate.
14 February 2013, the day the world focused on this security complex. In the early hours of the morning, 4 shots rang out and screams were heard. As daylight broke, it emerged that celebrity athlete Oscar Pistorius had shot and killed his girlfriend.
I'm going to miss you all so much.
The victim, 29-year-old model Riva Steenkamp. Hours later, first images of Pistorius being taken into custody. His arrest sparked world headlines. Pistorius made his first court appearance. On the 15th of February, he began the legal fight for his life. He applied for bail, and for the first time, the world got to hear his version of events. In court, an emotional Pistorius sobbed uncontrollably. In a sworn statement, he said he shot at the bathroom door to kill an intruder. On February 22, Magistrate Desmond Nair granted Pistorius 1 million rand bail, but with strict instructions. The conditions were later challenged successfully by the athlete at the High Court in March. On the 3rd of March this year, the much publicized and talked about trial began at the North Gauteng High Court. With scores of local and international media scrambling for space, it was dubbed the trial of the century. Pistorius' neighbors described what they heard.
Moments before the shots were fired, she had petrifying screams. I heard that female screaming fearfully.
The state painted a picture of a gun-loving Pistorius who has a violent temper. His ex-girlfriend Samantha Taylor among the witnesses.
He said that Oscar screamed at you.
Yes.
Was it one occasion or more?
On more occasions, my lady.
The deed Pistorius shot and killed his girlfriend finally emerged.
Bullet perforated here, but the arm was now in contact with her and she was a bit facing down.
And for the first time, Pistorius told his side of the story.
I thought that there was a burglar that was gaining entry into my home. And then I heard a noise from inside the toilet. Before I knew it, I'd fired 4 shots at the door.
But under grueling cross-examination, Pistorius contradicted himself. 2 of his legal team's experts also contradicted the athlete's testimony. But it was revelations from Pistorius' psychiatrist, Dr. Meryl Foster, that would change the course of the trial. She told the court he suffered from a general anxiety disorder. It saw Pistorius admitted to this psychiatric hospital for a month-long mental evaluation. The defense then turned to Pistorius' disability to explain his reaction.
His ability of fleeing is severely impaired, and his ability to ward off danger is severely impaired.
In August, the final showdown.
So there's objective proof for his version, supported by objective empty bladder, and it refutes this direct intent.
His intention was to kill a human being, dolus directus.
The verdict will finally bring to a close a grueling trial that grabbed the attention of the media and the world. Mangoba Mkulu, SABC News, Pretoria.
If you've just joined us, Paralympic blade runner Oscar Pistorius will know his fate as Judge Thokozile Masipa takes the podium to start delivering judgment in a short while on a trial that has lasted over 6 months. The prosecution and the defence ended their final arguments over a month ago in the murder case against the double amputee who shot his girlfriend Reeva Steenkamp on Valentine's Day last year. Today, it's the turn of the judge who went through a pile of evidence to seal Pistorius' fate. Pistorius claimed that he mistakenly shot Steenkamp, thinking there was an intruder in his home. The prosecution alleges the Olympic runner intentionally killed her after an argument. Well, on this fateful day, we cross live to our reporter on the scene as always, Griselda Lewis, on what is expected to transpire throughout the day. Good morning, Griselda. I understand you have a guest with you, but just set the scene for us, please.
Well, a very good morning to you, Eben. Well, just to bring you up to speed with the latest developments, Oscar Pistorius arrived just a few minutes ago here at the North Gauteng High Court on certainly what is one of the most important days in his life. You know that the races that he has run over the years and really excelled in certainly very important chapters in his life, but this would certainly be one of the most important of all of those as Judge Thokozile Masipa begins handing down her verdict in this matter. Just before that, much to the media's glare, into a media scrum outside the court here, Carl Pistorius, Oscar Pistorius' brother, and his, I can call him pillar of strength, arrived here at the court on a wheelchair. You will recall, of course, several weeks ago he was involved in a near-fatal car accident, and there was speculation this morning on whether he will continue to receive rehabilitation or he will come to the court. Certainly you would see it as very important for him to be here today. You would recall he was always the one giving Oscar Pistorius great support since the bail application as well. And we've heard inside this court as well that when Oscar Pistorius and Carl lost their mother, it was Carl Pistorius who and his sister army. So basically, in this case, what will happen today is that Judge Thokozile Masipa will go through the testimonies of the 37 state and defense witnesses who testified in this matter, including the testimony of Oscar Pistorius, to determine which of those was credible and which of those was not. But also, very importantly, South Africa's image around the world, as this case has taken the international stage. What sort of image has been portrayed of South Africa in this matter? South Africa's image, its reputation. To chat a bit about that to us now is Mr. Tebe Ikalafeng, who is a brand expert. Mr. Ikalafeng, thank you very much for your time this morning.
Thank you, Priscilla.
Has South Africa's image, reputation, taken a knock as a result of the Oscar Pistorius murder trial?
I don't think it's taken a knock. I think it has been tested, and I think it's come out in flying colours, because I think what you've noticed, certainly how Judge Masipa has handled this entire trial, has been fair without fear or favour.
The world's media is here. You were in awe when you saw the media scrum that was taking place just a few minutes ago. But certainly South Africa's justice system as well, very much under the spotlight. Has it been a fair trial so far? That's what the international media is asking. Is South Africa's justice system in accordance with standards around the world? Those are some of the questions. What's your take on the judicial system and the spotlight that has been cast on?
Well, certainly South Africa's constitution is always held up as one of the finest in the world, an example not just for emerging worlds, but really around internationally for emerged worlds as well. So here what we have seen now, we've seen that constitution being tested and really standing to the test of being seen to be fair and treating everybody equal under the law. And I think as South Africans, we can be proud that we have not had any hiccups in this trial. It has gone according to what one expects of a world-class international country.
Well, there's always been a word that South Africa is full of crime. South Africa, some have even gone on to say, is the capital of violent crime around the world. Do you think, with the presence of the international media here, that would give credence, given that this case is so much in the spotlight? Certainly doesn't paint a full picture, but does it give credence at all?
Well, I mean, this was not a random crime committed by people from outside. It was two people who knew each other very well. So I don't think necessarily that this case itself says anything about South Africa's crime status in the world. But of course, there's always been those perceptions about South Africa and crime. But we did see during the World Cup when those perceptions were persistent and people came to South Africa and they realized that this is just another country like any other country in the world, which has got its weaknesses and has got its strengths, but we've got the system and the judicial system to deal with these matters, and certainly I'm not worried about that story.
There's also brand Oscar Pistorius, put South Africa on the map, known around the world. Brand Oscar Pistorius, to what extent, if at all, in your view, has it taken a knock, if at all?
The brand Pistorius was you could almost parallel it with brand South Africa, because it's an individual who overcame challenges, who overcame what could have been debilitating circumstances and triumphed over them, and in many ways just like South Africa triumphed over 20 years ago over the apartheid system. So certainly for Oscar Pistorius, this is a turning point. I do not think that he'll ever be the same person that he ever was, and this trial certainly has put paid to his brand. I think for him to recover from this, whether he's guilty or whether he's free, will take tremendous amount of redoing, which I think is going to be absolutely rather impossible.
Well, I think, also a lot of spotlight has been put on Judge Thokozile Masipa. I've been reading some of the tweets this morning and some of the newspapers, also in the international press on the internet, saying that in South Africa we're looking at a situation where you have a woman presiding over this case, a black woman from the townships, a woman who did not come from a privileged background, presiding over a case of a privileged young man a white privileged young man. Do you think that speaks for South Africa and how far South Africa has come in terms of transformation? First of all, we have a woman judge who's dealing with this particular issue. In terms of the reputation, in terms of the image, are you able to give us some insight on that?
Well, I think it speaks very well to South Africa. It really does speak to this nation which has been able to remake itself. Because you think about it, this is probably the most high-profile case we've had in the history of South Africa, other than 1964 when Mandela went to jail in the Rwanda trial. So I think what in this instance, it really doesn't matter whether she comes from an underprivileged background or whether Oscar comes from an underprivileged background. She's a highly credible, highly experienced judge, and in this instance, that's the role that she's playing with aplomb.
Always very insightful. Thank you very much, Mr. Tebe Kalafeng, who is giving us some insight into South Africa's reputation, South Africa's image, the image of the judiciary as a result of the Oscar Pistorius murder trial. We're expecting proceedings to get underway in the next few minutes, and certainly we're waiting to see which of those witnesses really that Judge Thokozile Masipa's testimonies will actually go through. And certainly what we're expecting, one of the primary testimonies for her to focus on is that of Oscar Pistorius. Was Oscar Pistorius a reliable witness or was he not? Certainly all of that will be unpacked this morning, but the final verdict, the full verdict, certainly, Eben, we're expecting only tomorrow when we'll know what Oscar Pistorius' fate is.
Thank you very much, Chrisola Lewis, live outside the North Gauteng High Court, bringing us that update. As you can see, it's a hive of activity. We're only minutes away from, the verdict starting, and it's probably the most anticipated verdict in the last decade or so in the history of the planet that we're living on. But let's take a look at what you're talking about on social media around this trial. What are you thinking? Andrea says, Oscar trial, premeditated murder, ? Culpable homicide, ? Less than 24 hours to the final judgment. Well, less than 24 minutes to the final judgment. And Oscar's fate, I can tell you. Judgment day has arrived. Oscar Pistorius trial, Oscar trial, says Tsiki Mokoena. Oscar verdict, 11 September. The ominous 9/11. Yes, of course, this fateful day 13 years ago. A few planes flew into the Twin Towers in New York, changing the world as we know it. Ndalu Nkosi says, Judge Masipa gave herself about a month to prepare the ruling, which is expected to take 2 days to deliver. Thank you for the heads up there. Very nice of you to let us know how things will proceed today. Let's take a look at the front pages of the world. Of course, there is other news in the world at the moment. The Independent leads with a scramble for Scotland. This after Prime Minister David Cameron pleaded to the people of Scotland to save the Union. Down Under, the Australian says terror attacks, plans in place. This comes after a small number of Islamic radicals have settled intentions to conduct terrorist attacks in Australia. Is Australia a legitimate target, sending troops all over the world? The International New York Times leads with, as 9/11 sanctuary goes public, glimpses of the lives that were lost. This is today marks 13 years since the World Trade Center was attacked in 2001. Now, where were you when the World Trade Center was attacked on September 11th, 2001? We all have a story to tell when it comes to that specific moment in history in New York. Many on that day had even a more shocking and horrific experience, watching it live as it unfolded in the skies above them. We happened to find the following clip this morning of amateur footage taken of that blood-chilling moment when a second plane hit the World Trade Center. Take a look at this.
Oh my word! Oh my word! I'm sorry I screamed. That's on purpose, Alfred. Somebody is doing this on purpose. Oh my goodness. Oh my goodness.
Yeah, when the second plane hit, I think the world realized that it was not merely an accident that happened, and it dawned upon us what was really at play. The world has never been the same since. You're watching Newsroom on SABC News.
Go on. Go explore. Go with the waves. Lead the brave. Go bold. Go strong. Drive. Dare. Go everywhere. To oceans where no one's gone.
Welcome back. You're watching Newsroom here on SABC News. Now, many of us still remember just how taken aback South Africa was when the news broke on Valentine's Day last year that Oscar Pistorius had shot and killed his girlfriend Riva Steenkamp. Now, since then, Oscar's legal battle and some of his personal struggles have unfolded in front of the media's lens. Let's just take a look at some of the events that have taken place. The 14th of February last year was the day police confirmed they arrested Pistorius at his Silver Lakes home in Pretoria. The day after the incident, Pistorius appeared in the Pretoria Magistrates Court where prosecutors announced they would pursue a charge of premeditated murder. Then, on the 19th of February, Riva Steenkamp's funeral was held in Port Elizabeth and Pistorius appeared in court for the first day of his bail hearing. Here his legal team said Pistorius thought Steenkamp was an intruder. Then on the 22nd of that month, Magistrate Desmond Nair granted Pistorius R1 million bail. Conditions included that Pistorius surrender his passport and any weapons in his possession. Later, his bail restrictions were eased by the High Court in Pretoria, allowing him to leave South Africa if he wanted to compete internationally. And at the end of the last year, the athlete was charged with premeditated murder and with violating the Firearms Control Act. Then we can't forget that this case has been groundbreaking for South African media houses. This year, on the 19th of February, media groups asked the High Court for permission to broadcast Pistorius' murder trial, and later a 24-hour TV channel dedicated to the entire trial was launched. On the 3rd of March, the trial started in the High Court in Pretoria, where Pistorius pleaded not guilty. Later that month, the state closed its case after calling 21 of the 107 witnesses on its witness list. And just last month, the state and defence presented their closing arguments, where Barry Rue accused the state of being selective in the evidence it chose to accept for its case. Here, both Pistorius and Steenkamp's fathers made a debut appearance at the trial. Now, Eben, all of this brings us to today, where Judge Thokozile Masipa will hand down her judgments as we expect over the next 2 days. But I'll leave it to you to talk a bit more about that.
Yeah, thank you very much, Anine. Well, we are joined now by University of Johannesburg law expert Alton Hart to talk about legal matters. Good morning, Alton. Thanks for joining us.
Good morning, Eben, and thank you for having me on the show.
The big day is finally here. It's about a year ago. It seemed as if it would never come. What are your views about the past couple of months, what we expected, or is it even bigger than you expected, how this whole scenario play out, and maybe your expectation today?
Yeah, I can say that the media played a big role in what happened in the Oscar trial, and it was like I didn't expect the trial to go this far at this length, and also the detail that was shown to the public as to how criminal trials are ran in South Africa. I think that was a good thing for the South African public to actually see what happens in the courtrooms and actually give them a better understanding of how judges, prosecutors, and defense attorneys go according to their business in courts. And I think that was a good thing. And there's now, from my personal opinion, I have a couple of things that I think might happen today. But if we look at the completeness of the package, it's like there's three possible outcomes that can come here. They can find Oscar guilty of murder, culpable homicide, and also they can find him guilty on the firearm charges. But that's not just a summation of what I gave you, but one can also just go into each of these charges individually and get the spin-offs thereof.
Premeditated murder, which some experts say will be difficult in this case. What's your view on it? And then what are the sentencing procedures that would follow all of those three scenarios that you're looking at?
Yeah, well, I think firstly we need to clear up the issue of premeditated murder. Our Criminal Procedure Act 51 of 1977 makes mention of murder. Now, when it comes to bail applications, there's Schedule 5 and Schedule 6, which makes the distinction between murder and premeditated murder. So in this case, premeditation, the court will only look at it to see if there was an intent on the side of the accused to actually commit the offense of murder. But it will just be a verdict that says murder, but not premeditated murder. But premeditation will only be looked at when the court is trying to establish if there was intent. So when they talk about premeditated murder, it was just for the bail application for Schedule 6 and 5 to see in which schedule it falls.
It falls, yeah.
So people need to just make that distinction.
And you making that distinction for us, people are interested now in the numbers. Mm-hmm. What numbers and what would be fair and would justice be seen to be done? If you had to put a number out there, what would you say?
If one looks at the scenario now, Oscar is a first-time offender, and in terms of Section 277 of the Criminal Procedure Act, there are certain minimum offences that's applicable if Oscar is found guilty of murder. If he's found guilty of murder because he's a first-time offender, he might get a life sentence, a 15-year sentence, because he's a first-time offender. That's the minimum sentence that the court must give him if he's found guilty of murder. But the court can also go to life sentence, although he's a first-time offender.
You talk about first-time offender. How does the other charges then fit into the picture of a first-time offender? We're talking about the gun charges and the firing of a firearm in public place and so forth. How does that then tie in if you're a first-time offender? It's certainly not in mitigation, I would think.
No. The thing is what the state tried to do with bringing, because if one looks nicely at the other charges, the gun charges, it was outside the jurisdiction of this court. It was brought to that court to actually trump up the charges against Oscar to try and paint a certain picture of the accused. And I'm not siding with the accused, but that you could see that was the clear intention by the state to actually bring as much as possible charges so that they can hook him on something and show a certain character of the accused to the public and to the judge as well. So those charges, but the thing is what Section 277 says specifically is of an offence. And when they refer to murder, they refer to murder. So if he gets found guilty on the gun charges, it won't really affect the minimum sentence on murder. It will still remain the same because it's not the same offences. It's two different offences, falls into different schedules as well.
As a practitioner, do you think he will, or what do you think are the chances of him walking away a free man tomorrow after the judgment?
I think there is a possibility, and me coming from a defense side, I always look at the evidence and see that there is a possibility that they might find in favor of him. But one has to break down the blocks from start. But I don't think, in my personal opinion, that they will get him on murder. Culpable homicide, I think there's a strong case for the state. Because I don't feel that the state, because they made a big issue about dolus directus and dolus eventualis. Yeah. But I don't think that the state worked a lot to actually prove that intent, that Oscar had the intent to kill the deceased. And I think the state should have focused more there. And I think then they could have gotten him on murder. But culpable homicide, because on his own version, he said that he acted negligently. And I think the judge might just come back tomorrow and give us culpable homicide.
So when you talk about that kind of negligence, what plays out after that is probably then a civil action. How do you see a civil action play out? And would it be advisable to the Steenkamp family to look at civil action?
The thing is, like the civil action, it's always there for a person to take. But now again, then one should go and look at, was Riva actually supporting a family? Because then a family will bring an action, say, for loss of the breadwinner or something to that effect. Yeah. But previously, and it was in the media, that Oscar was actually supporting Riva's family financially. So will they be successful? I doubt it, because if Oscar can just prove that he was supporting the family, then obviously they've never lost a breadwinner.
Let's talk about the cost of this trial. We saw last week that, Oscar Pistorius have sold off most of his properties to carry the cost of this trial. What do you think this trial would have cost Oscar Pistorius up until now?
If one just looks at the amount of experts that was used, the tests that had to be undertaken and all the necessary behind-the-scenes investigations, I think that to get these experts to do, it can cost you a couple of rand. And especially with specialist experts, it can cost you up to hundreds of thousands of rand. So I think that this trial could have chased Oscar into bankruptcy, if one can put it that way. But then again, Oscar, being a world icon, I think it's not unrecoverable, but it will take him time to recover. But I don't think after this, and if one takes his evidence into account, he will actually recover from this, because this is something that will be carried with him for the rest of his life. And I think, and also if you look at his legal counsel that he had there, he had attorneys representing him and 2 advocates, junior and senior counsel. So that can also cost him a couple of rands, because it was like, I think it's up to 45 days that they spend in court, and senior counsel can charge you in the vicinity 30 to 40,000 rand to stand in court for a whole full court day.
Now, some people are talking that there are already some books in the offing, books being written, or most of it done already and will be published shortly. What is the legal position on that? Can Oscar Pistorius, if found guilty, benefit from that, or innocent benefit from that? What is the legalese, as it were?
It depends on what the content of the book is. Because if the book is specifically dealing with Oscar and his character and things that is like normally considered as being private information, then obviously they need his consent to actually publish a book to that effect. If he consents and they agree, they come to some sort of an agreement that he will benefit from the proceeds, then I think it can work for him, where he would like come and say, Oscar, the real version, something to that effect, and then the book can work for him. But also it can also just bring another side. Sometimes also people do things in hindsight to actually cover up their tracks.
Yeah.
One never knows. There's always that doubt.
Why don't you ask you finally, the media's role in this trial? It's been very much a trial by media in a way. Do you think that this had an impact on the overall trial, and it will have an impact on the verdict that we'll see in the next couple of days?
I think that the media's role in the trial had an impact on the trial, because there was a lot of things that when I was looking at the trial that I could see that the prosecutor or the defense attorneys could have canvassed, and they didn't want to do it. And everybody, the witnesses, it looks like they knew that there's cameras in the courtroom, and they were always like trying to put their stories in such a way that they won't contradict themselves, always looking, and sometimes you might lose some of the actual demeanor of the witnesses and even the prosecutor and the defense attorney who acts in this case. So the media played a role in it. People is aware there's cameras, so they would act differently as to when we're in a private room and talking.
Absolutely.
Then you get a different response as well.
Yeah, there's definitely been that sort of effect. But thank you very much, Elton Hart from the University of Johannesburg, joining us, giving us your views on this sensational trial. Well, it's past 9:30. It's 9:32 a.m. This morning. We're still waiting for Judge Masipa to come out of chambers to start proceedings at the North Gauteng High Court. Let's take a look at some of the other comments or some of the other scenarios that's playing out on social media right now. No, that's not comments, that's our Facebook page. Okay, what's happening on our Facebook page? That's Newsroom's Facebook page. Today, more than 150 journalists are expected to fill courts GC and GD in the North Gauteng High Court in Pretoria for the judgment in the Oscar murder trial. Then crowds are expected to gather in New York City today for the 13th anniversary of 9/11. We'll have a lot of coverage of that on our page. And then the Sonke Gender Justice Group is calling on government to commit more resources to fighting violence against women, especially those that are being killed by their partners. You can find all of those stories and a whole lot more on our Newsroom Facebook page. That's one that we keep updated almost to the minute. Let's go back to the comments. What are you talking about? Well, of course, 9/11 very much on people. The Fresh Prince. Mendes is his name, not the real Fresh Prince, I would think. Rest in peace to all of those lost on 9/11. Yes, that's 13 years ago. That's a sentiment that will reverberate around the world today. Leader of Lunacy says, I don't see the point of remembering something like that. It brought pain and suffering. Yes, we have to deal with that in order to deal with the pain and suffering. Well, court has started. Let's go to the North Gauteng High Court for proceedings with Judge Thokozile Masipa.
In 2013, the accused stayed at house number 286, Bush Willow Street, Silverwood Country Estate, Silver Lakes. The house was a double-story with a main bedroom on the first floor. The accused slept in the main bedroom, which had ensuite facilities, that is a bathroom and a toilet. To reach the bathroom from the main bedroom, one had to walk through a passage. Although there was no door separating the main bedroom from the bathroom, there was a door to the toilet that opened to the outside, that is, into the bathroom. The toilet was a small cubicle. The main bedroom had a sliding door that led onto a balcony. There were blinds on the windows and thick curtains which hung on the windows and the sliding door. When the blinds were closed and the curtains were drawn, the main bedroom was dark. On 13 February 2013, the accused spent the evening in his home with his girlfriend, Riva Steenkamp. In the early morning hours of 14 February 2013, the accused shot and killed Steenkamp, the deceased. At the time the shots were fired, the deceased was inside the locked toilet. As a sequence to the above, the accused was charged with the murder of Riva Steenkamp, read with the provisions of Section 51, subsection 1 of the Criminal Law Amendment Act, number 105 of 1997. In addition, he was charged with the following counts. Count 2, contravention of Section 120, subsection 7 of the Firearms Control Act, number 60 of 2000, in that the accused is guilty of the offense of contravening the provisions of Section 120, subsection 7, read with Sections 1, 103, 121A, Section 121, read with Schedule 4, and Section 151 of the Firearms Control Act, 60 of 2000, discharge of a firearm in a built-up area or any public place. The indictment carries on in that on or about 30 September 2010, and while traveling in a vehicle with other passengers on a public road or near Modderfontein in the district of Kempton Park, the accused did unlawfully discharge a firearm without good reason to do so by firing a shot with his own 9mm pistol through the open sunroof of the car they were traveling in. Alternative to count 2, contravention of Section 123B of the Firearms Control Act, number 60 of 2000, that the accused is guilty of the offense of contravening the provisions of Section 120, subsection 3B, read with Sections 1, 103, 121A, Section 121, read with Schedule 4, and Section 151 of the Firearms Control Act, 60 of 2000, reckless endangerment. In that on or about 30 September 2012 and at or near Modderfontein in the district of Kempton Park, the accused, in the circumstances mentioned in count 2 above, discharged a firearm, to wit, his 9mm pistol, with reckless disregard for other passengers in the car and or people in the vicinity. Count 3, contravention of Section 120, subsection 7 of the Firearms Control Act, number 60 of 2000, that the accused is guilty of the offense of contravening the provisions of Section 120, subsection 7, read with Sections 1, 103, 121A, Section 121, read with Schedule 4, and Section 151 of the Firearms Control Act, 60 of 2000, discharge of a firearm in built-up area or any public place, in that during January 2013, and at Thatcher's restaurant, Melrose Ark, in the district of Johannesburg, the accused unlawfully discharged a firearm, to wit, a Glock 27 pistol, without any good reason to do so. Thatcher's restaurant is a public place. First alternative count to count 3, contravention of Section 123A of the Firearms Control Act, number 60 of 2000, that the accused is guilty of the offense of contravening the provisions of Section 123A, read with Sections 1, 103, 121A, Section 121 read with Schedule 4, and Section 151 of the Firearms Control Act 60 of 2000, negligent damage to property. In that on or about January 2013, and at or near Thatcher's restaurant, Melrose Ark, in the district of Johannesburg, the accused negligently used the firearm, to wit, a Glock 27 pistol, and caused damage to the floor of the restaurant. Second alternative to count 3, contravention of Section 123B of the Firearms Control Act, number 60 of 2000. That the accused is guilty of the offense of contravening the provisions of Section 123B, read with Sections 1, 103, 121A, Section 121, read with Schedule 4, and Section 151 of the Firearms Control Act 60 of 2000, reckless endangerment. In that on or about January 2013, and at or near Thatcher's restaurant, Melrose Ark, in the district of Johannesburg, the accused discharged the firearm, to wit, a Glock 27 pistol, at a table in the restaurant among other patrons, in a manner likely to endanger the safety of the people at his table and or other patrons and the property of the restaurant. The accused had, in discharging the firearm mentioned, shown a reckless disregard for the safety of the patrons or property of the restaurant. In count 4, contravention of Section 90 of the Firearms Control Act, number 60 of 2000, that the accused is guilty of the offense of contravening the provisions of Section 90, read with Sections 1, 103, 117, 121A, Section 121, read with Schedule 4, and Section 151 of the Firearms Control Act 60 of 2000, and further read with Section 250 of the Criminal Procedure Act 51 of 1977, possession of ammunition. In that on or about 16 February 2013, and at or near 286 Bushwillow Street, Silverwood Country Estate, Silver Lakes, in the district of Pretoria, the accused did unlawfully have in his possession ammunition, to wit, 38 times 38 rounds, without being a holder of a license in respect of a firearm capable of discharging that ammunition, b, a permit to possess ammunition, c, a dealer's license, manufacturer's license, gunsmith license, import, export, or in-transit permit, or transporter's permit issued in terms of this Act, and D, or is otherwise authorized to do so. The accused pleaded not guilty to count 1 and handed in an explanation of plea in terms of Section 112 of the Criminal Procedure Act 51 of 1977. He also pleaded not guilty to counts 2, 3, and 4 and the alternative counts. The accused was represented by Mr. B. Roo, SC, and KC Oldwage. Mr. G. Nell and Mrs. A. Johnson appeared for the state. I sat with 2 assessors, namely Mrs. J. Hansen Dutoy and Mr. T. Mazibuko. Explanation of plea. In his explanation of plea in respect of count 1, the accused described the incident as a tragic one, which occurred after he had mistakenly believed that an intruder or intruders had entered his home and posed an imminent threat to the deceased and to him. The following extract is from the explanation of plea. I quote 4.1. During the early hours of the morning, I brought 2 friends in from the balcony. I had shortly spoken to Riva, who was in bed besides me. 4.2. Unbeknown to Riva, to me, Riva must have gone to the toilet in the bathroom. At the time when I brought in the friends, closed the sliding doors, and drew the blinds and the curtains. 4.3. I had the bathroom window sliding open. I believed that an intruder or intruders had entered the bathroom through the bathroom window, which was not fitted with burglar bars. 4.4. I approached the bathroom, armed with my firearm so as to defend Riva and I. At that time, I believed Riva was still in bed. 4.5. The discharging of my firearm was precipitated by a noise in the toilet, which I, in my fearful state, knowing that I was on my stumps, unable to run away or properly defend myself physically, believed to be the intruder or intruders coming out of the toilet to attack Riva and me. There was no explanation of plea in respect of counts 2, 3, and 4. Admissions in terms of Section 220 of the Criminal Procedure Act 51 of 1977, in brackets, the CPA, close brackets. Admissions in terms of Section 220 of the CPA were handed in by agreement between the parties. In respect of count 1, the admissions made by the accused concerned, inter alia, the identity of the deceased, the date, the scene, and the cause of death. The accused also admitted that the gunshot wounds were inflicted by him, that the body of the deceased sustained no further injuries from the time of death until the post-mortem examination was conducted on the deceased body, and that Dr. Seyman conducted the post-mortem examination and correctly recorded his findings on Exhibit B. There were no admissions made in respect of count 2. In respect of count 3, the accused admitted that a shot went off while the firearm was in his possession. In respect of count 4, the accused made an admission that at all times relevant to the count, he had not been issued with a license to possess a .38 caliber rounds of ammunition. I now deal with the summary of events. In respect of count 1, the state case was that the accused and the deceased had had an argument, and that the accused had then intentionally shot and killed the deceased who had locked herself in the toilet. To support its case, the state called a witness, Mrs. Estelle van der Merwe, a resident at the same complex as the accused, who awoke a few minutes before 200 hours in the morning to hear what she thought was a woman's voice. To her, it sounded as if the woman was engaged in an argument with someone. She could not, however, locate the voice nor tell what language was being spoken or what was being said. Shortly after 3 o'clock in the morning, she heard what she thought were gunshots. Mr. Charles Peter Johnson and Miss Michelle Berger, husband and wife, stayed in an adjacent complex about 177 meters away from the house of the accused. They both had screams that they interpreted as those of a woman in distress. Mrs. Annette Stipp, who stayed in the same complex as the accused, about 80 meters away, explained that she heard 3 sounds that she thought were gunshots. A few minutes later, she and her husband Stipp heard someone crying out loud and a man shouting for help. Mr. Michael Raymond Tlengetwa and his wife, Ayontle Hillary, were immediate neighbors to the left of the accused house. Mrs. Tlengetwa woke her husband up to report that she had heard a bang. Soon thereafter, they both heard a man crying very loudly. Mrs. Tlengetwa heard a man crying, "Help, help, help." At 3:16:13, Mr. Tlengetwa called security to report the loud crying, but did not get through. He tried again at 3:16:36, and the call lasted 44 seconds. Caris Viljoenstander was another witness. She woke up and heard dogs barking. Thereafter, she heard a man shout, "Help, help, help." According to her, this was approximately 5 minutes before her father, Johann Stander, received a call from the accused at 300 hours 19. Mrs. Ria Motswane is another neighbor of the accused. When one is facing the house of the accused, she is the immediate neighbor on the right. She awoke to hear a man crying out very loudly. She did not look at the time, but estimated that it could have been 3:20 when she woke up. The accused denied the allegations that he killed the deceased intentionally. He also denied that there was premeditation. The essence of the explanation of plea, as well as the evidence of the accused, was that when he armed himself with his firearm and fired through the toilet door, he was acting in the mistaken belief that the deceased, who was then unknown to him in the toilet, was an intruder who posed a threat to his life and to that of the deceased. He had believed that the intruder or intruders had come in through the open bathroom window. He had earlier had the window slide open. At the time, he had his back to the bed just after he had awoken to bring in 2 fans from the balcony and to draw the curtains. He was therefore unaware that the deceased had left the bedroom to go to the toilet. Common cause facts, or facts which are not disputed. The following are common cause facts which relate to count 1 only. It is common cause that on 14 February 2013, shortly after 3 in the morning, screams were heard from the accused house, that the accused while on his stumps, fired 4 shots at the toilet door, that at the time the shots were fired, the deceased was inside the toilet, that the door of the toilet was locked from the inside, that the door of the toilet opened to the outside, that is, into the bathroom, that 3 of the 4 shots struck the deceased, that the deceased sustained a wound on the right thigh, a wound on the left upper arm, a head injury, and a wound on the web of the fingers, and that the deceased died from multiple gunshot wounds. Also common cause is that soon after the shots had been fired, the accused called for help, that he used a cricket bat to break down the door, remove the deceased from the toilet to the hallway downstairs, that he was very emotional soon after the incident, and that he was seen trying to resuscitate the deceased. The issues. It is clear, therefore, that the issues are limited to whether, at the time the accused shot and killed the deceased, he had the requisite intention, and if so, whether there was any premeditation. Notwithstanding the limited issues, a lot of evidence was laid, and counsel argued extensively over 2 days. It shall not be possible, nor will it serve any purpose to rehash the evidence in detail. Hence the summary of the evidence above. It should also be fruitless to attempt to repeat every submission by counsel. This court has, however, taken all the evidence, and that includes all the exhibits and all submissions by counsel, into consideration. I may add that there were a number of issues which arose during the course of the trial. These issues took a lot of the court's time, and correctly so, as at the time such issues were important to the parties. The issues concerned were, inter alia, whether or not the police contaminated the scene, the length of the extension cord that went missing from the accused's bedroom, and the authenticity of photographs of items depicted in various exhibits. Having regard to the evidence as a whole, this court is of the view that these issues have now paled into significance when one has regard to the rest of the evidence. The reason for that view will become clearer later in this judgment. I proceed to analyze the evidence. I deal first with count 1. There were no eyewitnesses. The only people on the scene at the time of the incident were the accused and the deceased. Notwithstanding this fact, there was no dearth of witnesses who were willing to assist this court to determine what could have happened on the morning in question. Several witnesses gave evidence regarding what they heard or what they thought they heard at the time of the incident. A few could, in addition, tell the court what they observed after the incident. This court is indebted to all those witnesses, and this includes expert witnesses who sacrificed their time and resources to come and assist in this matter. The record of the evidence runs into thousands of pages. Thankfully, the nub of what is an issue can be divided into 3 neat categories as set out hereunder. gunshots, sounds made by a cricket bat striking against the door, and screams in the early hours of the morning. For purposes of this judgment, gunshots, sound made by a cricket bat striking against the door, and screams will be discussed together as they are to an extent inextricably linked. It is common cause that on the morning of 14 February 2013, shortly after 3 o'clock, various people heard gunshots, screams, and other noises that sounded like gunshots emanating from the house of the accused. As stated before, various state witnesses had screams that they interpreted as those of a woman in distress. They had noises that sounded to them as gunshots. The defense admitted that there were shots fired that morning, but added that there were also sounds of a cricket bat striking hard against the toilet door, and that the noises sounded similar and could easily have been mistaken for shots. This was not contradicted. During the course of the trial, it became clear that some of the sounds that witnesses interpreted as gunshots were actually not gunshots, but sounds of a cricket bat striking against the toilet door. It was also not contradicted that the shots were fired first and that the striking of the door using a cricket bat followed thereafter. That there was a misinterpretation of some of the sounds is clear from the following. It is common cause that only 4 gunshots were fired by the accused that morning, yet some witnesses stated that they had more than 4 shots, while others had less than 4. This can only mean that some of the sounds that were heard were interpreted as shots could have been from the cricket bat striking against the door. It could also mean that some of the witnesses missed some of the sounds that morning, either because they were asleep at the time or their focus was elsewhere. For example, a witness could have been on the phone at the time. Significantly, Ms. Berger refused to concede that she could have missed hearing the first sounds, that is the shots, as she might have been asleep at the time, and that what she heard was a cricket bat striking against the toilet door. The evidence of this witness, as well as that of her husband, Mr. Johnson, who sought to corroborate her evidence, was correctly criticized, in my view, as unreliable. I do, however, think that they were unfairly criticized for having made almost identical statements to the investigating officer, Captain van Aert. After all, they did not write their statements and had no say in the format of the statements. They merely related their version to Captain van Aert, who has his own style of writing and his own vocabulary. The witnesses could not have been expected to know why he wrote in the manner that he did and why he used certain words and in what sequence. Captain van Aert was the only one who could have explained that. He was not called to do so. That omission, therefore, cannot be used against the witnesses. I do not think that Mr. Johnson and Ms. Berger were dishonest. They did not even know the accused or the deceased, so they had no interest in the matter. They also did not derive any pleasure in giving evidence. They stated that they were at first reluctant to come forward to give evidence until after the bail application, because they thought it was the right thing to do. They simply related what they thought they heard. They were, however, genuinely mistaken in what they heard, as the chronology of events will show. In my view, it is absurd to conclude that the evidence of witnesses must be rejected in its entirety merely because the witnesses failed to describe the events in exactly the same way. In any event, contradictions do not automatically lead to the rejection of a witness's evidence, as not every error negatively affects his credibility. Before determining the credibility of a witness who contradicted himself or herself, a court has to evaluate all the facts, taking into account the nature of the contradictions, their number, their importance, and bearing on the rest of the evidence. In brackets, CS v. Mkhohle, 1990, Volume 1, SACR 95, capital A in brackets. It is easy to see why the witnesses would be mistaken about the events of that morning. The distance from which Berger and Johnson heard the noises put them at a distinct disadvantage. Both of them and the Sips were adamant that they, in addition to the shots, heard screams of a woman in distress. So sure was Johnson and his wife that a couple had been attacked in their own home that Johnson got up early that morning to do something about improving his own security at his home. However, this court has approached the evidence of every witness in this matter, not only that of Johnson and Berger, with the necessary caution. There is a very good reason for this. Factors such as how long a witness has known a suspect, if at all, proximity, visibility, mobility of the scene, the opportunity for observation, and duration of the incident play an important role and are always taken into consideration by our courts. In brackets, CS v. Mtetwa, 1972, Volume 3, SA, 766, in brackets, capital A, close brackets. In the present case, we are here dealing with sounds, identification, and voice or scream identification, as well as interpretation that experts refer to as intelligibility, something that is even more tricky in my view. There is no reason why the same guidelines used in identifying the features of a suspect should not be applicable to voice identification. In Kasu, none of the witnesses had ever heard the accused cry or scream, let alone when he was anxious. That in itself poses a challenge, as the witnesses had no prior knowledge or a model against which they could compare what they had heard that morning. Even Miss Samantha Taylor, who confidently stated that when the accused was anxious or agitated, he sounded like a man and not like a woman, had to concede that she had never heard him scream when he was facing a life-threatening situation. In any event, the evidence of Mr. Lin, an acoustic engineer, cast serious doubt on whether witnesses who were 80 meters and 177 meters away, respectively, from the accused house would be able to differentiate between a man and a woman's screams if the screams were from the toilet with closed windows. Also militating against the conclusion that it was a woman's scream that was heard that morning is the following. 1. At the time of the incident, there was no one else in the accused house except the accused and the deceased. Therefore, it could only have been one of them who screamed or cried out loud. 2. According to the post-mortem examination report, the deceased suffered horrendous injuries. Professor Gert Simon, who conducted the post-mortem examination on the body of the deceased and compiled the post-mortem examination report, marked Annexure GW715, noted 4 gunshot wounds. These were on the head, 1 on the right upper arm, 1 in the right groin, and 1 in the right hand between 2 fingers. In his evidence, Professor Simon described the wounds individually as follows. The nature of the wound on the right hip was such that, I quote, there would have been almost immediate instability or loss of stability pertaining to that limb or hip, close quote. He explained that a person could transport weight onto the opposite limb and stand only on one leg, but the probabilities were that the injured person would become immediately unstable. It would clearly also be a particularly painful wound. Asked whether the 2 injuries, that is the arm injury and the groin injury, were serious, he explained that both the injuries were so serious that either of them could have killed the deceased. The injury to the arm was particularly devastating as the shot had fractured and shattered the right upper arm. Describing the head wound, Professor Simon stated that would have been an, I quote, immediately incapacitating injury, close quote. A person sustaining a wound of that nature would be almost immediately incapable of voluntary action of any kind. He or she would probably also be immediately unconscious. The respiratory functions would have been compromised substantially. There was also damage to the brain, as well as substantial fracturing of the base of the skull, but minimal blood in the airways. This suggested that the deceased probably did not breathe more than a few seconds after sustaining this wound. The shots were fired in quick succession. In my view, this means that the deceased would have been unable to shout or scream, at least not in the manner described by those witnesses who were adamant that they had heard a woman scream repeatedly. The only other person who could have screamed is the accused. The question is, why did he scream? His version is that he screamed after he had fired the shots when he realized that the deceased was not in the bedroom. That version has not been contradicted. The time of the screams and the reasons for the screams make sense when one has regard to the chronology of the events of that morning. The screams were heard just after 4 shots were fired and before the 3 sounds from a cricket bat were heard. I continue to explain why most witnesses got their facts wrong. The fact that this case attracted much media attention, especially soon after the incident, and the fact that it became a topic in many homes also did not assist. Almost every witness who was asked under cross-examination if he or she had followed the news relating to the events of 14 February 2013, or the bail proceedings, or the trial proceedings, responded positively. A few witnesses considered that they discussed the case with others before they took the witness stand. Mr. Darren Fresco, for example, who gave evidence for the state in counts 2 and 3, stated that when someone called him the day before he was to give his testimony to inform him that his name had been mentioned in court, he was curious and wanted to know the details. He therefore took the witness stand with foreknowledge of what he might be asked. I venture to say that Mr. Fresco was not the only witness with such a disadvantage. I refer to it as a disadvantage because it does affect the credibility of a witness, as a witness might unwittingly relate what he or she had heard elsewhere, as though he or she had personal knowledge of the event. I am of the view that the probability is that some witnesses failed to separate what they knew personally from what they had heard from other people or what they had gathered from the media. The last reason why this court had to approach the evidence of each witness with caution is that the incident happened in the early hours of the morning when most of the witnesses who gave evidence were in bed. Mrs. van der Merwe was in and out of sleep. Mr. Johnson, Ms. Berger, as well as Dr. and Mrs. Stipp were roused out of sleep by either screams or what sounded like shots. Ms. Berger described it as a confusing night, while Dr. Stipp got his times clearly wrong. It was not disputed that Dr. Stipp heard the first sounds, heard screaming or shouting, heard the second sounds, went to the accused house, and assisted Mr. Stander to call 911 in that order. Counsel for the defense submitted correctly that the evidence of Dr. Stipp was unreliable as to the times when different events in this matter unfolded. He submitted further that Dr. Stipp's evidence in some instances was tailored with the objective of assisting the state's allegation. I do not agree with this submission. Dr. Stipp had no interest in the matter and would therefore have no reason to tailor his evidence to assist the state. I do not believe that he colored his evidence against the accused. On the contrary, he showed no bias against him. He told this court that when he arrived at the accused house, he observed a distraught accused attempting to resuscitate the deceased, that he was praying to God to save the deceased, that as soon as the accused learned that he was a doctor, he implored him to do something. When asked if he thought the accused's distress appeared genuine to him, he did not hesitate to respond positively. The facts above have been set out to demonstrate the difficult terrain that this court had to traverse to arrive at its conclusion. It follows from the above that it would be unwise to rely on any evidence by the witnesses, and this includes those witnesses called by the defense who gave evidence on what they heard that morning without testing each version against objective evidence. Human beings are fallible, and they depend on memories which fade over time. Thankfully, as it shall be clear from the chronology of the events, this court is in a fortunate position in that it has objective evidence in the form of technology, which is more reliable than human perception and human memory, and against which all the other evidence can be tested. Phone records which tell us exactly who made the call, from which cell phone to which cell phone, and at what time, were made available to this court, and we took full advantage of that. There is also a record of the duration of each call. It is significant that although most of the timelines were initially introduced into evidence by the state, it was the defense which analyzed the timelines and set out hereunder and addressed the court on each. When I asked State Counsel if the timelines were common cause, his response was that the only recordings of... I'll rephrase. When I asked State Counsel if the timelines were common cause, his response was that only the recordings of the various calls were common cause, giving an impression that the rest of the timelines was disputed. However, there was no address forthcoming from the state to disturb the timelines as set out hereunder. In any event, one can safely use the phone records, which were made between 300 hours 15:51 and 300 hours 17, as a base to arrive at the approximate times when the shots were fired, when the screams were heard, as well as when the sounds of the cricket bat was striking against the door were heard. In addition, the accused's phone records are also available. A perusal of these records showed that at 3:19:03, which was minutes after the sounds caused by a cricket bat were heard, which was approximately 300 hours 17, the accused was on the phone calling Stander. A minute later, he called 911. Thereafter, 1.5 minutes later, he called security. I now proceed to set out the chronology of events. 1. At 2:20, security activated guard track next to the house of the accused. 2. Approximately between 3:12 and 3:14, first sounds were heard. These were shots. 3. Approximately 300 hours 14/15, accused was heard shouting for help. 4. Approximately between 300 hours 12 and 300 hours 17, screams were heard, or screaming was heard. And 5. Approximately 300 hours 15, accused was seen walking in the bathroom. 6. 300 hours 15:51, the duration was 16 seconds. Dr. Steve telephoned the Silver Lake security. 7. 3:16, the duration was 58 seconds. Mr. Johnson called and spoke to Strubenskop security. 8. 3:16:13, Mr. Michael Ntlengetwa made his first call to security. This call did not go through. 9. 3:16:36, the duration was 44 seconds. Mr. Michael Ntlengetwa made his second call to security. 10. 3:17, Dr. Stips attempted to make a call to 10-111, 11-317. Second sounds were heard. These were cricket bats striking against the door. 12-319-03. The duration was 24 seconds. The accused called Johannesburg. 13-320-05. The duration was 66 seconds. Accused called 911. 14-321-33. The duration was 9 seconds. The accused called security. 15-322-05. Duration 12 seconds. Peter Baba, the security, called the accused. 16-03-22. Baba, the security, arrived at the house of the accused. 17, approximately 3:22, Johan Stander and Karisi Feljun arrived at the house of the accused. 18, approximately 3:23-24, Dr. Stip arrived at the house of the accused. 19, 3:27-06, Johan Stander's call to 911 in the presence of Dr. Stip. 20, 3:27-14, Dr. Stips attempted to call security. This call did not get through. 21-3-41-57, an ambulance arrived at security gate of Silverwoods Estate. 22, approximately 3:50, paramedics declared the deceased dead. 23, approximately 3:55, police arrived at the accused house. The chronology above gives a feel of where various witnesses corroborate one another's evidence and where they contradict one another. An analysis of the evidence using the timelines as a basis will also assist this court to determine whether the state has proved beyond reasonable doubt that the accused had direct intention and premeditation to kill the deceased. We'll take a 2 minutes break. Court will adjourn.
Thanks, Mom. Have fun. You too.
Purchase an Audi A4 with xenon lights for only $3,899 per month and receive a complimentary 20,000 kilometre extension to your Audi freeway plan.
Zoom into Africa. This